let's see what law says about the grievance redressal process. First of all, let us understand what's the appropriate forum for filing a complaint. That's very, very important because we should know where the complaint needs to be filed if such kind of instance has happened. And it's not only for females, it's for males also who know that one of their colleague has faced such kind of harassment instance, and he or she wants to support that female who suffered such kind of instance. So what is the appropriate forum of complaint? One is ICC or IC, which is in case the organization has more than 10 employees. All companies have to have an internal committee, which is called IC, and the complaint needs to be filed to the IC. Next is in any other cases where either the number of employees are less than 10, or still there are organizations, despite the number being more than 10, they still do not comply with the law. For those organizations, the local complaints committee, which is established by the labor offices in each district. So each district has a local complaints committee. In these committees, females from organizations where either those organizations have less than 10 employees, or maybe they belong to an unorganized sector, or if there are more than 10 employees, there are no ICs existing in those organizations. So where there are no ICs, there is a local complaints committee. The complaint needs to be filed with it. Third is police, in case the aggrieved woman wishes to approach. And the fourth one is SheBox, which is an online sexual harassment complaints portal set up by Ministry of Women and Child Welfare. So where here the female can file a complaint online. Composition of IC. So every organization with 10 or more employees need to have an IC. The composition being one presiding officer who's a woman employed at senior level at workplace from amongst the employees. Two, not less than 2 members who are employees of the organization. 1 external member from NGOs or law firms or associations who are committed to the cause of women. Half of the total members shall be women in every IC. IC has the power of civil court, the power to summon and enforce the attendance, examining somebody on oath and requiring production of documents, witnesses, etc., etc. Who can make the complaint? So either the aggrieved woman herself, legal hire, relative, or a friend where she's not able to do that herself, a co-worker, guardian, qualified psychiatrist or psychologist where the female suffers mental issues and she's not able to do that herself, an officer of the NCW or the State Women Commission, and any person who has the knowledge of the incident or authority under whose care she is receiving treatment or care, etc. Most important, the complaint needs to be in writing and submitted with the IC of the organization. Essentials of a well-written complaint, very, very important, because you know this slide specifically has come out of after a lot of practice in the law, after a lot of instances that have happened, have been sorted out by us. So therefore, for a well-written complaint, the details of the aggrieved woman and respondent both needs to be mentioned, along with the reporting structure amongst themselves. The report cannot be anonymous, this means. So an anonymous complaint will not be entertained by the IC. Name of the aggrieved woman and her details should be mentioned in the complaint. It should be addressed to IC and not the employer or HR. Concise, simple language, easy understanding of the complaint, and details of the exact incident, date, time, witness, whatever she can include. Circumstances preceding and following the incident need to be recorded. Whether the complainant asks the respondent to desist from the unwelcome act. Again, like I said, for the females, it is high time that we start saying no in the first instance. And if we've started saying no and still that act continues by the respondent, then in our complaint, it should be mentioned categorically that I had categorically told him not to behave with me in such a manner, still he continued, and therefore I'm writing this complaint. Just an example. Append as many documents as possible in whatever format, WhatsApp, emails, call details, photographs, recordings, SMSs, etc., etc. Do not state any fact that is false or incorrect, because that's going to hamper the investigation and that's going to be against the complainant. And the relief that is sought from the employer, the female should mention that what relief she's seeking from the employer. The relief might be as simple as a written apology from the male colleague, or it may be as serious as terminating the male colleague, or it may be for transfer of either of them from that place, etc., etc. Now, coming to the dispute resolution mechanism, there are two ways of doing it, either through conciliation or through investigation. So conciliation means sitting across the table, discussing the matter, and coming to a conclusion and closing it. Where the complainant requests for a conciliation meeting, the IC can convene a conciliation, should convene a conciliation meeting and take it under conciliation and come to a conclusion. So complaint gets filed within 3 months of the incident of sexual harassment to the IC, and it can be filed beyond 3 months, but there should be justifiable reasons, and the IC should record it in writing and then condone the delay. However, within 3 months is what the law prescribes. Here, the aggrieved woman requests for a conciliation, and then the IC will call both the parties, sit across the table, and come to a conclusion, logical ending of the complaint. The settlement gets recorded, copy of the same is given to both the parties, and then there is no further inquiry. Here in conciliation, the settlement cannot be monetary. So the victim cannot say that if I may be paid a monetary settlement amount for me to close the complaint. No, that's not allowed under this. Coming to inquiry, where the female where the complainant aggrieved woman says that I want a complete inquiry into my complaint, the IC has to follow the inquiry procedure. And the procedure as defined under the law is that within 90 days of the occurrence of incident of sexual harassment, complaint gets filed with the IC. Now the IC has to act like a quasi-judicial body. A copy of the complaint will be provided to the respondent within 7 working days, and the respondent gets a time of 10 working days to respond on that complaint. Then the copy of the response gets provided to the victim or aggrieved woman. Then she will go through it. She might have any additional instance or document to share or witness to be produced. Then she will respond to it. There may be multiple to and fro of documents. Complaint, respond, complaint, respond. Then, however, the IC gets a total of 90 days time to close the complaint, complete the inquiry. And within these 90 days, there may be 10 sittings, there may be 1 sitting, there may be 15 sittings, depending on the complexity of the matter. And however, 90 days period is specified under it's fixed. For all inquiry meetings, 3 members of the IC are mandatorily required to be present, including the presiding officer. So the quorum is 3 members of IC, including presiding officer. Okay. Inquiry, once the inquiry is completed within 90 days, inquiry report gets provided to employer within 10 days from the date of completion of inquiry. So from the date of filing of complaint, it's a 100 days process defined under the law. And cut to cut, it has to work. You cannot, say that one was not present, or the aggrieved woman was not present for the hearing, or the respondent wasn't present. No such excuses. Here, as a resultant, so the outcome of the inquiry can be either the allegation gets proven. So IC will pass its judgment for taking action, suggesting action for sexual harassment as misconduct, where the allegation doesn't get proven. For example, there were not enough witnesses, or the female, I'm not saying that the incident might not have occurred. It might also be the scenario where she has not been able to prove it, and therefore the employer cannot take an action, or the IC cannot recommend an action to the employer. So no action by the employer. Where, however, it is proved that the female with the wrong intent or a malicious intent filed a complaint with the IC to settle scores with the colleague, or maybe, I don't know, maybe just like that. So similar punishments are also provided under the law for the females also. So females have to be wary of the fact that they can also be punished. Both the parties are free to appeal to the appellate authority within 90 days. Now, in the interim, this 90 days period, the aggrieved woman can also request the IC to give her some interim relief. For example, the law has prescribed interim relief such as transferring the aggrieved woman or respondent from the place of work, granting paid leave to aggrieved woman up to 3 months. Now, this is up to 3 months. So the aggrieved woman cannot claim it as her right to get a 3 months paid leave. I have personally faced an instance where the aggrieved woman said, I would not say requested, because she insisted or ordered the IC that it is my right, I should be given a 3 months paid leave. So when asked, what will you do after 3 months? Then she said, I will see what I have to do. But at the moment, this is my right. And when we showed her that it is up to 3 months, she started questioning on the interpretation of this by the IC. So again, it's not a right. It's the female, the aggrieved woman can request, and depending on the circumstances or her physical or mental condition, the IC may grant paid leave to aggrieved woman up to 3 months, and it's a paid leave. Restrain the respondent from reporting on workplace of aggrieved woman and assign reporting of aggrieved woman to another officer. These 4 reliefs, interim reliefs, are provided under the law. Such other relief as may be prescribed from time to time under the law. Now, where the action, where the sexual harassment gets proven, what action can be taken by the IC? What actions can be recommended by the IC? The respondent may be asked to submit a written apology. A warning may be issued to him. He may be reprimanded. His promotions or pay rise or increments may be withheld, may be terminated. Some counseling session may be advised for him, or in extreme circumstances, a police complaint can also be filed against him. Now, here under inquiry, there is a provision for compensation. In conciliation, there was no compensation, but after inquiry gets completed, if it is found that the female was sexually harassed, there is a provision for compensation, which is basis the loss in career opportunities faced by her, the medical expenses faced by her, and also it also depends on the income and financial status of the respondent. Apart from this law, there are other criminal laws which provide penalty for instances of sexual harassment, like IPC section 354A provides up to 3 years of imprisonment for the offense of sexual harassment. IPC 354B provides an imprisonment of 3 to 7 years for assault or use of criminal force to women with intent to disrobe her. IPC 354D for stalking provides imprisonment for up to 3 years. IPC section 509 provides for imprisonment of up to 3 years for any word, gesture, or act intended to insult the modesty of a woman. Any harassment by an indecent portrayal of women in books, films, photographs, painting, etc. Imprisonment up to 2 years is prescribed under the law called Indecent Representation of Women Prohibition Act. So these are, apart from the anti-sexual harassment laws, the penalties, imprisonment provided under other laws.
Welcome to Complinity Technologies. Complinity is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. Complinity is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000+ laws and 24,000+ compliances, all in an integrated platform that is easy to use with automated alerts and risk management capabilities, is why compliance managers, general counsels and chief financial officers choose Complinity every time. Join the most innovative and prestigious brands that use Complinity. Automating your compliance management. Request a demo at complinity.com.